Okay, so in a huge Supreme Court case, the entire future of environmental law really came down to one simple sounding question: where do you even file the lawsuit? Let's break down why the answer to that question is such a big deal.
And I'm not just talking about real estate here. In the world of environmental law, the specific courthouse you end up fighting in can literally be the #1 factor in whether you win or lose. It's a high-stakes game of legal geography. You see, this whole case is basically a fight over where to have the fight, and it all kicks off with a federal program that's designed to make our fuel a little bit cleaner. Now, this program, it's pretty complicated, but it basically boils down to this. Big oil refineries, they have to blend biofuels like ethanol into their gasoline. But, the law created this sort of escape hatch for the smaller guys, the ones who could get financially crushed by the cost of doing that. So instead of deciding each one of these cases individually, the EPA just issued two massive omnibus notices. Think of it like a giant single announcement that bundled all 105 petitions together. They used one single nationwide reason to deny every last one of them. And, well, that move kicked off a huge legal battle. And this simple-sounding question of venue, which is just the proper location for a lawsuit, that became the entire case. It's a strategic call that is so important, it went all the way up to the Supreme Court just to get an answer. So, how do you even decide where to sue? Well, the answer is actually right there inside the Clean Air Act itself, which draws a very specific map for these kinds of legal challenges. The law sets up this 3-step test. Step 1, if an EPA action is nationally applicable, meaning it affects the whole country, the case has to go to the D.C. Circuit Court. Simple enough. Step 2, if the action is locally applicable, just affecting one area, it gets filed in the local court. But here's the kicker. Step 3, the exception. It says that even a local action, if it's based on a nationwide reason, gets bounced right back to the D.C. Circuit. This little exception is the heart of the whole dispute. Now, what's so fascinating here is that both the refineries and the EPA looked at that exact same rulebook and came to completely opposite conclusions about what it meant. So the refineries argued that the effect of each denial was local, right? It only hurt their one facility in their one town, so they should get to sue in their local court. But the EPA came back and said, whoa, not so fast. They argued that their reasoning was national. They used the exact same logic to deny everyone, everywhere. So any challenge should be heard in the one court that handles these big national rules, the D.C. Circuit. This disagreement created what we call a circuit split. That's when different federal courts across the country just can't agree on what a law means. And that, right there, is one of the main reasons the Supreme Court steps in, to be the final referee and provide one clear answer for everyone. So the case gets to the Supreme Court. How did they decide to untangle this legal knot? When the decision finally came down, it wasn't even close. By a pretty decisive vote of 7-2, the court gave a clear answer to this whole venue puzzle. But here's the interesting part. Instead of just picking one side or the other, the court's majority opinion, which was written by Justice Thomas, did something a little more nuanced. It created a 2-part solution that actually gave a little something to both sides before landing on a final answer. So here's how the court split the difference. First, they actually agreed with the refineries. They said, yes, the action of denying a single permit is in fact a local thing. But then, in step 2, they turned around and sided with the EPA. They found that the reasoning behind that action was national in scope. And because of that crucial exception in the law, a national reason is what triggers the rule that sends the case straight to the D.C. Circuit. This quote right here is the key takeaway. The court created a brand new legal test. From now on, if a nationwide reason is the primary driver of what looks like a local decision, any legal challenge has to be filed in Washington, D.C. It all comes down to what really motivated the agency's action. Okay, so what does this all mean in the real world? Its consequences go way beyond just this one case, and they're going to affect pretty much anyone who deals with environmental law. This ruling really reshapes the entire legal battlefield. It centralizes a ton of power in the D.C. Circuit, which is now going to hear way more of these big environmental challenges. Now, that could lead to more consistent environmental law across the whole country, which some people see as a good thing. But it also raises the bar for local groups who might find it a lot harder and a lot more expensive to challenge an EPA rule that's affecting their specific community, especially when the courtroom is potentially thousands of miles away. And that really leaves us with this fundamental question about balance. Is it better to have one court making consistent nationwide rulings to create predictability, Or do we lose something really vital when local perspectives and local impacts have to fight for attention in a courthouse that's hundreds or even thousands of miles away? There's definitely no easy answer.
And of course, just a quick reminder, our analysis is for entertainment and educational purposes only. This is not legal advice.